Okay, we will start with introducing Professor Elizabeth Sepper. She is a nationally recognized scholar of religious liberty, health, law, and equality. She has written extensively on conscientious refusals to provide reproductive and end-of-life health care and on conflicts over religion and insurance coverage. In addition to regularly publishing cutting-edge scholarship in her field, Professor Sepper frequently provides her expertise on reproductive health law to local and national media. Professor Sepper's most recent work focuses on legal, theoretical, and policy debates related to the anti-discrimination obligations of public accommodations under federal, state, and local law. She is the 2022 recipient of the MacDonald Merrill Ketchum Memorial Lectureship and Award for Excellence in Law and Medicine from the Hall Center for Law and Health at Indiana Law, a mouthful. And she is also an incredible faculty member here at the law school. We're lucky to have her as a faculty member, and we're lucky to hear from her today.
And Professor Stephen Vladek is the Charles Allen Wright Chair in Federal Courts at the University of Texas School of Law, and he is also a nationally recognized expert on the federal courts, constitutional law, national security law, and military justice. He has argued more than a dozen cases before the U.S. Supreme Court, the Texas Supreme Court, and various lower federal courts. He has testified before numerous congressional committees and executive branch agencies and commissions, and has also served as an expert witness in both U.S., state, and federal courts. Additionally, Professor Vladek co-hosts the popular National Security Law podcast with Dean Chesney, is CNN's Supreme Court analyst, and he is currently writing a book on the rise of the Supreme Court's shadow docket to be published in May 2023. He has received numerous awards for his influential legal scholarship, his prolific popular writing, his teaching, and his service to the legal profession. So we are very excited to have him here today as a member of the Texas Law faculty and to have this wonderful conversation about the impact of the Supreme Court's Dobbs decision. So if you could please join us in welcoming both Professors Vladek and Sepper.
We're going to start with a few questions from Lauren. Oh, okay, great. We're going to start with some pre-written questions, and then we're going to open it up to have ample time for Q&A. So with that, over to you.
Okay.
Okay, so thank you all for being here. We're really excited to talk to you. We're going to have something of an informal presentation, back and forth, sort of bounce back and forth, talking first about the opinion in Dobbs and then the implications of the decision across a range of healthcare and legal issues. So I'm going to just start off by giving a very brief overview of what Dobbs decided. I would take it from the interest here. We also got the preview of the draft, right? You've had a long time to be able to digest what was in the Dobbs opinion. But just to tee it up, so to set the stage, right? So Roe v. Wade is a 1973 decision that locates a right to abortion in the substantive due process clause of the 14th Amendment. So it's part of the liberty protected by the 14th Amendment. There were lots and lots of Supreme Court cases following Roe. And in 1992, in Planned Parenthood v. Casey, the Supreme Court reaffirmed the right to abortion, reaffirmed it as a due process interest, but also gave it some equality legs. So talked about how the abortion right was essential to sex equality in the United States. Now, Casey changed the standard, right? So we moved from this trimester framework to a standard built around the undue burden. So states couldn't unduly burden abortion. And as a bright line rule, they couldn't ban abortion prior to viability, which is around 23, 24 weeks of pregnancy. So Mississippi passed a law that banned abortion after 15 weeks. We had seen a number of these bans. They'd all been struck down by federal courts, including the Fifth Circuit, getting Mississippi's ban, easily struck it down under the Supreme Court's case law. But then the Supreme Court took the case, and it became clear that it was going to be about something very big. Mississippi at that point changed its litigation strategy. It had been arguing a 15-week ban did not unduly burden abortion because women could get abortions before 15 weeks. They had plenty of time, was the argument. Instead, the Supreme Court made clear they were interested in overturning Roe v. Wade.
Did something happen to lead Mississippi to change its position in the Supreme Court?
Well, a little state known as Texas. So no, the composition of the court had changed, which is also what had happened in Casey, where we thought, again, at that point with 5 Republican appointees, that the court might reverse Roe. This time we were right, so that the composition of the court would change the outcome. So in Dobbs, we had a full-scale, very explicit reversal of Roe and Casey as being unfounded, and a holding that the 14th Amendment of the Constitution no longer protects a right to abortion. And the test that Justice Alito used was one that the Supreme Court has sort of toggled on and off in different contexts and with different degrees of focus on history, but one focused on whether a right is deeply rooted in our nation's history and tradition. And what he said was, well, we had criminal bans on abortion from around the time of the Civil War, and therefore there wasn't a deep historical foundation for a right to abortion, but in fact the contrary, that what we saw was a regime of restriction of abortion. Says a lot more in the opinion, but where I'm going to leave you is that now the standard is rational basis. So the same sort of review that a court would apply if you tried to make a constitutional argument, I'm building a business and I want to have 4 parking spaces instead of the mandated 2, and a court would say, we're just going to do rational basis here. There's a rational basis that a legislature could have for restriction, and that's now the standard that applies to abortion and any restrictions on abortion that states want to put into place.
So I would just add, I think the other part of the majority opinion that is probably of less immediate significance in the reproductive rights context, but more significance in broader conversations, is also the justifications the majority deploys for why it's okay to overrule Roe and Casey, right? The sort of the stare decisis part of Justice Alito's analysis. And I think the key there is whether you think it's right or wrong, it clearly weakens, right, the force of stare decisis as a constraint on the Supreme Court in future cases, so that the sort of arguments about why the court was bound to follow its precedents that we would have seen last year look a little different now. And to me, part of what I know we want to spend most of our time talking about the implications of Dobbs. I actually think the fight over the implications of Dobbs is really well encapsulated in the very different concurring opinions in Dobbs penned by Justice Kavanaugh and by Justice Thomas. So let me start with Justice Thomas. Justice Thomas says, I've been telling you people for years that substantive due process is bunk. Never mind that the slaughterhouse cases, get in the way of this whole story. That's too inconvenient for this. And now that we've taken the first step, we should take the next step. And so Thomas's concurrence says, now that we've recognized that the relevant test is this deeply rooted in historical tradition test, we should revisit Griswold versus Connecticut about the right to contraception. We should revisit Obergefell versus Hodges about the right to same-sex marriage. Now, he leaves out interracial marriage, but I don't think... I actually am going to defend him on this, right? Those of you who have not yet read Loving versus Virginia, Loving is not just a due process case. Loving is also an equal protection case. Perhaps Obergefell should also be an equal protection case. That's for another time. The point is that Justice Thomas, for better or for worse, calls it like he sees it and says, good, right? Now it's open season. And this is where I actually think it's the Thomas concurrence that impels Kavanaugh to respond, right? Kavanaugh is not really responding to the joint dissent. He's mostly responding to Thomas when he says, whoa, everybody, slow down. right? And he says two things. One, this is just about abortion. We are not coming for same-sex marriage, right? He doesn't tell us why, right? He doesn't say, the analysis in the majority opinion is necessarily limited to the context of abortion. He just says, trust me, people, right? And there's actually force to that, right? Why should we trust Justice Kavanaugh? Because he's the median vote. And so if he says, I'm not going to overrule Obergefell, that's not a legally binding promise, but it's a commitment of at least some force. But the other thing he says, and this is the part that I think is the segue to the next part of the conversation, he says, we are returning the question of reproductive rights to the states. We are washing our hands of this abortion business. We are done, right? Bye. And has this incredibly, to me, halcyon, if not naive, view that there won't be further litigation, right? That returning it to the states means we're going to have this binary universe where some states ban abortion and some states protect abortion, but it'll be clean and it'll be neat and there'll be no chaos. And I just think that events of whether that Professor Sepper would have told you that was never a realistic position, I think whether you thought it ever could have been, right? The events of the last, 2 months have shown why it wasn't. Right? That, it's not just complication and confusion over trigger laws. It's not just complication and confusion over when abortions are medically necessary, right? It's that there's going to be messy litigation about every single sort of one of these offshoot sort of second-generation questions, litigation that's very likely to end up in the Supreme Court. And my favorite part is when he says, and don't worry, right, rich people, about traveling out of state for abortions, because obviously there's a constitutional right to interstate travel. Where? And again, I don't think he's arguing in bad faith. I think he believes all of these things, but I think they give up the ghost a bit, right? About how what's going on here is not necessarily high constitutional principle, but rather fairly low constitutional politics. And that I think is, so I think that's the problem in trying to sort of segue to the next step of the conversation, which is, what does Dobbs require versus what do we think this court will do when variant X reaches it?
Yeah, I think a related issue is a point that Justice Alito brings up where he says, abortion has really screwed up constitutional law. Which way to get the subject wrong? It's the Supreme Court that decided to do that. And he's talking about things like standing, about free speech, and mootness. So he's talking about a number of constitutional principles or doctrines that change when they come into contact with abortion. Now, if you're Justice Kavanaugh, that issue spotter, right? If we're going to fix those constitutional distortions, doing away with abortion in some states doesn't get that for you because the Supreme Court has distorted, for instance, free speech, and I would say religious liberty jurisprudence any time that a state tries to, for instance, mandate disclosure around abortion. And so those cases would have to go to the Supreme Court if the Supreme Court were actually interested in fixing the doctrine and doing away with some of the abortion distortions that it's created.
I think the irony is that, if anything, the court is going to now have more abortion cases in the next 5 years than it had in the last 5 years because some of these variations are going to be so complicated and so important. We're going to get to this, but just to give one example, right? Just last week, a district judge here in Lubbock blocked the Biden administration's guidance to emergency rooms for the requirement under this federal statute EMTALA, right, to provide abortions as a part of emergency medical care. Meanwhile, a judge in Idaho, right, ruled that EMTALA preempts Idaho's abortion ban, right, in cases in which it applies. So, that's just one of the dozens of flashpoints that it's not hard to see getting right back to the Supreme Court. And I think the question is going to be is there still a unique abortion jurisprudence, or is the court really going to do what Kavanaugh says it's going to do and clean this mess up? So why don't we start? I mean, why don't we talk with regard to Dobbs? I think we might break Dobbs' implications into 3 categories, right? The first is for abortion access itself, right? The second is for other pregnancy-related medical care, and the third is for other rights. So why don't we sort of take those in order? What do you see as the sort of both the immediate and the sort of longer-term implications of Dobbs for abortion access?
Yeah, so I mean, as Professor Vladek said, we've seen repercussions rather quickly, right? It's been 2 months since the Dobbs decision. And what we have now is in more than half the states, we know that they are either likely to ban abortion or have already banned abortion through a number of mechanisms. So some of them have pre-viability bans. Now, for those of us who don't usually think about early 20th century statutes that are not on the books somehow coming back on, this has been a bit of a learning process. But in a number of states, there are early 20th century or late 19th century criminal abortion bans where there's now quite a bit of litigation over whether they are good law. In Texas, for instance, there's a 1925 ban that was struck down in Roe v. Wade. And in fact, then the state of Texas in 1974 totally redid its penal code. That provision was not there anymore. It hasn't been in the code in that entire period. Well, the Attorney General put it back, this time into the civil code, resulting in all sorts of litigation, and still the status is actually not at all clear. The Texas Supreme Court said it could be enforced civilly, but at least not yet criminally.
The Texas Supreme Court did a really weird thing, right, where it basically sort of kept in place, right, a trial court injunction barring criminal enforcement of the 1925 statute, but not civil enforcement. It's like, well, at that point, yes, criminal enforcement is not civil enforcement, but if you're a provider, right, it's liability.
Yeah, so we have these pre-viability laws, and we have them in a number of states. There's also the trigger bans. These were triggered by the issuance of a decision overturning Roe v. Wade, and those have now pretty much all been triggered, though again, some litigation in states where the process of triggering was a little bit unclear. And then we just have some sort of pre-viability bans. So there are states that have 6-week bans, for instance, that were clearly unconstitutional under Roe, but now are in place.
And we have both.
We have everything. We're real innovators in this area. There's a lot of criminal law on top of criminal law, with some civil laws on top of those as well.
But so one of the points that I think gets lost in some of the news coverage, but actually becomes really important, is you have these laws on the books, and then there becomes a question of how realistic is it that they're actually going to be enforced, right? And so with SB 8, that's complicated because literally any Joe can bring a lawsuit to enforce SB 8, at least in theory. But with the criminal statutes, it's supposed to be local DAs, right? And Attorney General Paxton has tried to argue that he has the authority to enforce directly. The Supreme Court's been like, not so much. So it seems like part of what's messy about all of this is that the law on the books may not necessarily reflect the reality on the ground, especially in jurisdictions with more progressive prosecutors. Is that a fair assessment?
No, I don't think so. And here's why. It's that, so there's a number of progressive prosecutors or just big city prosecutors who say, we're not going to make it a priority. We're not going to criminally prosecute abortion-related crimes, or at least not, usually we won't. That's just not a reassurance to any provider, right? So, and by provider, I mean not only abortion providers, which the medical profession has sort of marginalized and made more vulnerable. I mean doctors called to the emergency department to perform an emergency DNC, a dilation and curettage, the standard procedure to remove the fetus from the uterus, right? It's not going to be a reassurance to them, and partly it's because of 2 things. The trigger ban has a civil penalty, and the AG can bring that action, and it's $100,000 per abortion. But even more important from the perspective of a healthcare provider, whether a physician or nurse or so on, is that there's mandatory license revocation for violating the trigger ban, and that's much more valuable than $100,000, right? So I do think there is reassurance from the DAs, and here's how I think it works. Because of the way the criminal law works, right, there are a lot of questions about accomplice liability or conspiracy. So, if you help a friend, for instance, obtain medication abortion for a self-managed abortion, you are potentially subject to a number of criminal charges under Texas law. So the best way to be safe is to perform all the criminal acts, including talking about it, if at all, in, say, Travis County and nowhere else.
Or in California.
Well, yes, but that's logistically more complicated, right?
Yes.
Yes, but in terms of the local prosecutor issue, yeah.
But it seems like there's the practical question about abortion access and there's the legal question. And I want to come back to sort of where they bleed over, right? Which is one of the issues I think folks have been paying a lot of attention to is the concern that states would ban out-of-state travel, right, to obtain abortion-related services in states that still allow them. I don't think we've seen any state jump that shark just yet. And so in that respect, maybe Justice Kavanaugh's concurrence is actually doing some work. So at least for the well-to-do, right, still okay to hop on a plane and go to blue states. But what about medicinal abortion? I mean, medication abortion, we've seen a real shift in how large a volume of abortions are performed through medication. How does that complicate the story?
Yeah, so it means that a number of people self-manage their abortions, which is medically safe, legally in some states quite risky. In Texas, at the moment, all the abortion-specific laws exempt the person who is pregnant. So self-managed abortion usually requires 2 pills. So there have been a number of things that have happened. So there are lots of organizations that mail medication abortion illegally into the state of Texas. And we have SB 4 passed just last year, which criminalizes providing medication abortion, mailing medication abortion into the state for the purpose of an abortion. So we're seeing people get access here without going anywhere at all. What else we're seeing is people traveling for legal abortions. And there things are starting to get even more complicated because providers are now concerned and funders are now concerned because it's usually a 2-pill regimen for medication abortion. So someone who travels to New Mexico takes the pill there, but reasonably, of course, wants to come home. You have to wait 24 to 48 hours to take the second pill. So they want to come home and they take the second pill at home, right? And then all the issues around criminal law come in that and now there's concerns and some requirements by the providers that people stay and take the second pill in New Mexico or in a state where it's legal. But I want to hear from you about the right to travel and how you think that it might play out either in what legislators do or what the constitutional analysis would look like.
So the Supreme Court has, I guess the strongest word I can say is hinted, right, in a number of opinions that the Constitution protects a right to travel, i.e. that states cannot prohibit their own residents from leaving the state to pursue activities that the state disapproves of. So this actually is not like a weird application of the right. This is actually like the core of the right to travel is the idea that I should be allowed to go do things that are legal in Illinois, right? Even if Texas doesn't like casino gambling, Texas shouldn't be able to prevent me from going to Nevada. That's the idea here. There are 2 problems with this. The first is, if you asked me for the Supreme Court case most squarely on point for a right to travel, the best I've got is a 1999 decision called Sines versus Roe, which really tiptoes around whether this is a thing. And the second is, right, the right to travel is, I think I can say this, not in the text of the Constitution. And so the very sort of defense, right, against the perhaps most onerous implications of Dobbs is based on the very constitutional analysis that Dobbs purports to repudiate, right? Which again is why the Kavanaugh concurrence is, I think, so tricky. So I think it is almost certainly the case that there would be 5 votes on the current Supreme Court to strike down a state law that made it a crime to leave the state to procure an abortion that is lawful in another state. But I think that not because I can tell you the legal arguments, but because it's just, a political calculus. And that's a risky, we're not there yet. No state has done this. And just, for the 1Ls in the room, right? A state could not make this criminal ex post facto, like retroactively, right? So we're fine for the moment, but I think it's also worth noting that the state legislature most responsible for these onerous, ridiculous restrictions is not currently in session. Hi, Aaron. Right? And that gets us back to the problem of where this goes.
Yeah, what I could see before, saying it's a crime to leave the state, something like anyone who aids and abets someone to travel in Texas to go elsewhere has committed a crime.
I think that runs into the same problem, right? I think if there's a constitutional right to travel, then states are going to be in trouble if they try to make it a crime to facilitate the exercise of a constitutional right. Again, I can't point to a case that says that, but and to be cynical, right? I think there's a reason why this is the line that Justice Kavanaugh wants to draw. The cynical view here is because how do I say this without getting? I don't think I can say this without getting into trouble. Wealthy Republicans need abortions too, right? So I don't have a good principled legal explanation for why this is the law. I just have a sense that this is where we're going, barring another shift, right, in the composition of the court. All right, but so that's the sort of the immediate right access to abortion question. We are seeing, I think, much more aggressively than at least some had expected, this bleeding over into non-abortion pregnancy-related medical care. And so does it surprise you that that's happened? Are there ways to sort of draw this line more sharply so it won't happen? And what do you think the biggest flashpoints are?
So we're seeing lots of impacts, lots of stories coming out. I think mostly anticipated by people who have been following this. So what's clear, so if with the fall of Roe v. Wade, there's a number of things that end up happening, right? So in analysis in the sort of reproductive justice cases, the right to determine that you would terminate your pregnancy was thought to be sort of a greater right that encompassed lesser, right? So you had great liberty that encompassed lesser liberties, like doing foolish things like drinking a ton of alcohol while you're pregnant, or riding a motorcycle, or whatever, all sorts of things. That is not a pregnancy complication, just for the record. So, might be contraceptive, but it's not abortive. So we've seen it bleed over to a lot of different areas. So miscarriage management was always going to be closely related because the standard procedure for handling a miscarriage is to perform an abortion procedure. So it was clear that that was going to be an issue. Now, one way that legislators could handle this and do away with some of the worst repercussions that we've seen already show up is to have a lot of very clear exceptions in the statute or by regulation. We've seen Louisiana attempt this a little bit. They have an exception for fetal anomalies where they've listed a laundry list of fetal anomalies that allow someone access to abortion.
God bless civil law.
Yeah, well, it's apparently not a particularly thorough list, and partly because OBGYNs will tell you pregnancy makes your body run amok in all kinds of ways. So in OB care, when you hear hoof sounds, you suspect a zebra because often a zebra shows up. So we have miscarriage management. We have ectopic pregnancies, which implant. usually outside the uterus. They can't be found sometimes. So we have an exception for ectopic pregnancies in Texas. The problem is about 10% implant outside of the fallopian tubes and therefore are not subject to that exception. I've learned this very strange term, pregnancy of unknown location, is apparently a thing because ectopic pregnancies are early. They are very dangerous. And so we're just seeing physicians not clear on how to handle emergencies. But beyond emergencies, right? If you become pregnant and discover that you have cancer, many kinds of cancer become aggravated by pregnancy. So they spread more quickly and you can't receive oncology treatments of most kinds while you are pregnant. But this is not an emergency. It's not life-threatening in the sense that these bans have defined it. We don't have rape exceptions anymore. We don't have health exceptions. So I think legislators could deal with some of these problems. But at this point, they're showing that they don't want to, that those exceptions that used to be standard in abortion restrictions are gone.
So my judgment is not as good as yours, so I get into a lot more fights on Twitter. But it seems like it is a common response of folks who defend the laws that don't create these exceptions, that the existing exceptions are sufficient, and that the problem is skittish doctors, providers, and other medical personnel who just aren't reading the laws correctly. It seems to me that approach is stunningly naive to the sort of chilling effect that SB 8 and SB 4 and the 1925 statute all create, which is doctors and providers and those who facilitate all face the risk of potentially ruinous litigation, even if at the end of the case, everyone agrees that the procedure fell within the exception. But how, is that fair? And second, if so, how do we persuade people that the law in the books is not necessarily the law on the ground?
So, I think that doctors are appropriately reading the laws in many of these places. A number of states have now moved to only having life exceptions. So if someone's life is at risk on an emergent basis, so you have to perform the abortion or they die. It is very hard to know what that means, right? So physicians will say, what does that mean? Life and death is not a matter of certainty, right? So are we dealing with a 90% likelihood? Could it be 50? Is 30 enough? So physicians have said, look, if I have a patient in the ICU attached to machines who is pregnant, I could say that given what you need in terms of ICU care, that if I don't perform a DNC, that person is very likely to die to a level where they would feel confident saying that was life-saving. Ectopic pregnancy, not so much because, right, you might need to wait until there are signals, right, until the abdomen starts filling with blood, perhaps, right? But just to give a sense, we're lawyers. What the heck does this mean? Because this is what doctors are going to ask. Okay, this is Mississippi's 15-week ban, which was upheld. It has a life exception, and has an exception for serious risk of substantial and, hold the phone, irreversible impairment of a major bodily function. So what I know from that is that you can have a serious risk of a substantial impairment of a bodily function. So maybe your lungs stop working. I guess if I can think as a doctor that I could get you back going in a month, is that good enough? It's not irreversible then. You're just on life support for a month, right? What's the big deal? I don't know how to read that as a lawyer, right? But that's what the lawmakers wrote, and certainly doctors can't translate this into medical practice.
Good times.
Yes.
I miss the old days when we talked about things like, can we go to war with, a non-state actor? This seems, more personal. I guess the other piece of this story is EMTALA, right? And I think, it's been in the news, but also I think it's it's one of the few places where federal law actually seems to speak to this. So can we talk a bit about EMTALA?
Yeah, so EMTALA is the Emergency Medical Treatment and Labor Act. It's a 1986 statute that means that when you go to the emergency room and you have an emergency medical condition, which is, it's not the normal reasons we go to the ER, right? If you have a broken leg, that's probably not an emergency medical condition as EMTALA defines it. But it's something where the doctors have to give you what's called stabilizing treatment in the statute, or you will suffer, the broadest definition is serious jeopardy to your health. But you can see that's broader than life-threatening. Serious jeopardy to your health.
Not necessarily irreversible, but not necessarily irreversible.
It doesn't have to be irreversible. It doesn't have to be a major bodily function, whatever that is. And so in those scenarios, doctors and emergency departments have to provide stabilizing treatment.
Can I add one? And, right, EMTALA 1Ls, right, is a spending clause statute, right? So the way the regime works is the federal government is funding this emergency healthcare treatment, and medical facilities that accept those federal funds are required to comply with the conditions EMTALA imposes for treatment.
Yeah, it's essentially all hospitals, and this is how health law works. The other place we actually see health law relevant to abortion is HIPAA, which, you know, notoriously is misused.
And misspelled.
Misspelled, 1P, it's not a female hippo. So that's another area where we've seen some protections with the federal government telling providers you can't just willy-nilly hand out information to law enforcement about someone you suspect may have self-managed abortion or otherwise. And then the Federal Drug Act. So EMTALA requires some treatment where a lot of these states ban treatment. So doctors have been stuck or are being stuck as trigger bans go into effect between the requirement of federal law that says provide this care and then the state ban that says if you do, you may go to prison. So we saw these competing lawsuits, very different procedural postures, and I'll be interested to hear what you think about those claims.
Yeah, so two lawsuits. I think chronologically, the first one was before both of the lawsuits. The Biden administration issued new guidance, right? Not changing the meaning of EMTALA, but basically reaffirming what had been the long-standing understanding of how EMTALA applied to abortion care in emergency rooms, emergency procedures. Then the Justice Department goes out and brings a civil suit against the state of Idaho. I think it was pretty clearly a test case, right? I mean, Idaho's ban is not the only one that runs into EMTALA. You guys might be wondering why Idaho. Idaho is in the Ninth Circuit, right? Which, you know, is not the Ninth Circuit of yore, but is still a far more heterogeneous appeals court with regard to the diversity of its judges than, I don't know, the Fifth Circuit.
But the ban in Idaho also was sort of at the far end.
Yes.
It only has a life exception, and it doesn't have an exception, I should say. If you are charged, it has a total ban, no abortions at all. If you are charged with a crime as a physician,
You have a defense.
You can have an affirmative defense that it was necessary to save someone's life. So you have
Which
to
then goes to
prove
the
it.
jury. But, I mean, Idaho is not unique in this respect, right? I think there's one other state that has I think part of it was not just that Idaho was an outlier. I think part of it was they were picking their forum a little bit strategically. And the idea was that EMTALA preempts the Idaho abortion ban, at least in cases in which EMTALA applies, and the federal government won a sort of a preliminary injunction from the district judge in the case, Judge Windmill. I haven't seen a notice that Idaho's appealing, but I'm sure it will. Then, not to be outdone, Texas Attorney General Ken Paxton filed his 28th lawsuit against the Biden administration in that hotbed of state legislative activity, Lubbock, where he had a 97% chance of drawing Judge Hendricks. I'm sure that had nothing to do with why he filed in beautiful downtown scenic Lubbock. And Judge Hendricks, perhaps not surprisingly. So the different, Professor Sepper mentioned the different procedural postures. The Idaho case is an argument that the Idaho ban is itself preempted by EMTALA. The Texas case is a challenge to the Biden administration's guidance, to its interpretation of EMTALA. So they are technically in different postures. They are basically asking the same question, which is everyone agrees that EMTALA will preempt contrary state laws. The question is, what exactly does EMTALA require? right? What is the scope of the preemption that everyone agrees the statute accomplishes? And so by blocking the Biden administration's guidance, Judge Hendricks is basically saying that EMTALA actually doesn't preempt nearly as much as the Biden administration thinks it does. That creates a pretty square conflict with Judge Windmill's decision in Idaho. And just to sort of be nerdy for a second, in a context in which this might go up to the Supreme Court pretty quickly, right? In which, the federal government may soon ask the Fifth Circuit to stay Judge Hendricks' decision in order to allow the Biden administration's guidance to go into effect in Texas and Louisiana and Mississippi. And if the Fifth Circuit says no, because it's the Fifth Circuit, then the Biden administration might go to the Supreme Court and ask it for a stay. So, I think the EMTALA issue, one way or the other, is probably the leading sort of contender right now for the first thing to get up to the Supreme Court. And I would just say, I actually think it's also perhaps the strongest of the cases for cutting some sort of terrain into these state abortion bans, right? Like an on-point federal statute that has been interpreted this way for 35 years since it was enacted, seems like a pretty powerful cudgel against at least the extremities of these bans.
Yeah, I mean, the important point is this doesn't it doesn't reverse Dobbs. It doesn't mean there's abortion access. What it means is where pregnancy complications become emergent, it's EMTALA that applies.
Right, not a state abortion ban.
Treatment is provided, not the abortion ban.
Right, and frankly, I actually think if this goes to the Supreme Court, right, I could see a universe where you get a unsigned, unexplained stay over maybe one or two public dissents, but not four, and then that's the end, and then the court washes its hand of this. But I don't know, we'll see. So all right, so that's pregnancy adjacent, right? Care. I want to leave a couple minutes before we turn to questions to talk about other rights, because there are some. So who are you with, Thomas or Kavanaugh?
Why not both?
I think that's hard.
So, there's been a lot of discussion about what rights are under threat, if any. For my money, the top two contenders are contraception and same-sex marriage. I think contraception, this is what it looks like. A state bans emergency contraception. A provider or a person who wants to take emergency contraception challenges the state statute.
Can you when you say emergency? I mean, can you clarify? Right? Are we talking Plan B? Are we talking mifepristone? Like which side of RU486? Like where are we here?
So RU486 is one name for medication abortion. Plan B is an emergency contraception. There's also ELA. There's also IUDs that can perform this function. So basically, and frankly, Plan B is just high dose oral contraceptives. So there's plenty of guides online where you can take basically 20 birth control pills over a period of time and it performs emergency contraception, which is to say it prevents the release of an egg, usually is how it works, right? So an egg never meets the sperm and that's it. It's not an abortion. It doesn't prevent, it doesn't end a pregnancy.
So you say it's not an abortion, right? And I agree with you that it's not an abortion.
Fair.
That is not the universal view of what an abortion is.
So, no. So most emergency contraceptions work by, the egg never meets the sperm. So most emergency contraception works exactly that way. There is some debate about whether any of them can operate by preventing the implantation of a fertilized egg, and some of them, certainly some forms of IUD, can do that. So there are some people who say that, that essentially life begins with the fertilized egg. A pregnancy doesn't begin with a fertilized egg because about 50% of fertilized eggs never implant. And
all of this science is very, sciencey.
It's a lot of parts we got in here, and so I think thinking about contraception, right? So part of the argument would be, well, Justice Alito says Abortion is different because it interferes with potential life. It's a killing. So if you take the view that a fertilized egg is a full human person, then you could try to expand in this direction, even if most forms of emergency contraception don't work this way. And we've already seen this from the Supreme Court and Hobby Lobby referring to medication abortion as abortifacients on precisely this sort of, frankly, attempt to confuse people. Pharmacists are very confused between the two. When when emergency contraception was introduced, they regularly confused it with RU46. They didn't understand the mechanism of action. And so I think that's the number one. And once that happens, a court would have to say, in some way, either this is actually abortion, which would not match up with medical knowledge at all, so we'd be in total denial of science, which is possible, or
something new and different for the Supreme Court.
Or a court would say, Dobbs did away with the abortion right. There's no substantive due process right to contraception. There's no history and tradition of contraception. This stuff is brand new, right?
The law the Supreme Court struck down in Griswold had been on the books since, the 1860s, I think, if memory serves, right? So, yeah, I think contraception is much more obviously the next flashpoint than marriage, right? I think I don't want to downplay the concern about marriage. I think anyone whose marital union depends upon Obergefell being good law is right to be worried about it. But I think it's a straighter path, both politically and practically, from the laws on the books right now. Now, mind you, some states like Texas still have marriage bans on the books. California, right? Prop 8 is still the law in California. But I don't see the sort of the political conditions getting there quite as quickly as, there's no risk of science confusion when it comes to marriage. That's not to say this is not going to change in a couple of years, right? It's worth pointing out that, 3 of the Obergefell dissenters are still on the court. But I think one is clearly much more immediate than the other.
Should we open it up?
Yeah, so the last thing I would say, I also even on Obergefell, I think it's worth distinguishing, this is not much of a salve, right? But even in the nightmare scenario where the court goes after Obergefell, I think there's a 0.00000% chance that it would then invalidate already lawful marriages, right? I think it would be a prospective ruling. That's not much consolation, but I think it's at least worth saying. All right, on that uplifting, horrifying, depressing note, why don't we throw it open to questions from the lovely crowd.
Should I stand up? I guess I'll stand up. Hi, I just had a question. We mentioned exceptions being dismissed in specifically Texas in cases of rape. Our governor has made a point to say that it's okay that we don't have this exception anymore because we're going to stop rape in the state. Do you know any of his policies that he's promoted to do that, and do you find them valid whatsoever?
I think that's a rhetorical question. I will just say that, if Governor Abbott has a mechanism for stopping rape, I might even vote for him. But I at least have not heard such a mechanism unfolded yet.
And I'll just add, rape exceptions were, seem both contradictory, right? If you believe that embryo or fetus is a person and abortion is killing, it was always a little bit off to say rape and incest were accepted, but it gave some public cover, even though the exceptions were very rarely used because they require people to come forward, and even if it's just as a matter to their physician in ways that don't always happen.
So I actually think it's worse than that, right? I think the rape and incest exceptions, to the extent they were politically necessary, right, we're giving up the whole frickin' ghost, which is that there were circumstances in which the legislatures thought abortions were appropriate, right? And if you believe that once you cross the line, that there are circumstances where it's appropriate, right? Why should we stop at rape? I mean, that to me is why that was always such a, sort of politically understandable but legally cynical, right, piece of the story. So, but no, I am not optimistic that Governor Abbott has figured out how to stop rape.
I know that there's been reporting about. I know there's been some reporting about women who have gotten abortions being charged under medical malpractice or unlawful disposal of tissue laws to criminalize their abortions. Do you see the Supreme Court addressing those sort of issues? And if so, where do you think they go with that?
So, as I said, the abortion-specific laws here and in many states don't allow for criminal charges against the person who's been pregnant. And that's basically what the law was while Roe was in place across the country. But we do know that thousands of women over a period of decades that we know of have been charged with crimes, everything ranging from child neglect to homicide, right? And some of those cases, many of those cases involve stillbirths, so where there's suspicion that it's actually infanticide. Many of them, maybe the majority of them, involve substance use. So there's like delivery of drugs to a minor is one of the charges that has been brought against people who miscarried or where their child was born exposed to narcotics. So I think we will see many more of those because Roe was a shield against some applications. And those sorts of charges, some would say they're going to apply to poor women, to people of color, to people in rural communities, people who are marginalized in some way. I would say yes, and I suspect there will be politically motivated prosecutions now in the works.
I would add to the Supreme Court part of the question, one of the things that Dobbs does is it defederalizes most of the law in this space so that unless there were some kind of freestanding federal constitutional objection to, for example, a fetal remains statute, those cases won't end up in the Supreme Court, right? They'll end up in the Texas Supreme Court or the Idaho Supreme Court. And, back to the political side of this, right? Those are state courts where the judges are elected. And where maybe there's actually some opportunity for political shifts to accomplish better outcomes in the law, but where it's going to be politically driven judicial outcomes, not federal constitutionally driven judicial outcomes.
Okay, does it work? Okay, hi. I hope I asked this in a clear way, but I had seen that Jonathan Mitchell in his Writ of Erasure Fallacy article, and then also some anti-abortion attorney generals kind of latched onto this idea that they can retroactively enforce laws that were previously enjoined against conduct that happened while they were enjoined, because an injunction doesn't actually overturn a law. If I asked that clearly enough or stated it, is there any possibility of that actually working? So
you asked that perfectly clearly. The short answer is I'm sure it will be tried. The good news, such as it is that as long as these laws are punitive, right, the ex post facto clause is going to do all the work we need, which is to say the Supreme Court's ex post facto clause jurisprudence, which people don't really study that much because we don't see this happen that often, is pretty clearly a functional analysis about whether the application of the criminal statute is to conduct that at the time it was committed was understood to be lawful. Not formally lawful, but understood to be lawful. So no, I do not think that that theory would be effective. I do think it might take a couple of cases, right, for the courts to say, there's this thing called ex post facto, and the ex post facto clause is only about criminal punishment. On the civil side, it's a slightly more amorphous due process objection, which I still think courts would likely sustain, but where there's a little more unpredictability.
From our online audience too. So if you want to take one of those, one of our viewers wants to know about what's going on in the arena of personhood and laws related to personhood, especially related to IVF treatments and fertility treatments. What's going on there?
So far, which were, whatever, 60 some odd days out from Dobbs' decision, we haven't seen much movement on personhood. So Louisiana's legislature considered a bill that would have expanded the definition of a pregnancy to include a fertilized egg anywhere. So a lot of these statutes say in the woman's body is a common formulation. And Louisiana was going to change that. So their IVF was in trouble because terminating or disposing of, as it's called, fertilized or embryos that have been grown would have become illegal in the state of Louisiana. So we haven't seen those. I suspect that what we will see first are prohibitions on genetic testing of embryos. So people undergoing IVF commonly test embryos to try to select the most viable embryos, or sometimes to control for traits. You can think whatever you want about that ethically, but maybe they want a girl with blue eyes, and that's what they are trying to select for. Or they're trying to select against certain disabilities. And I suspect we will see that. And just to give you a sense, I mean, Justice Alito gives us a number of legitimate interests that would allow the regulation of abortion or anything that would end potential life, and says the prevention of discrimination on the basis of race, sex, or disability. This is explicitly about those kind of laws that had started to be passed around, reason-based bans. So I think we could see that happen.
Hi, I guess I was just wondering when they talked about in Dobbs the fact that it's not an implicit right or deeply rooted in tradition, why we don't consider bodily autonomy, considering you can't force me if you were dying and you needed a blood transfusion and I had that blood, you can't force me to give that blood to save you. And I don't, I guess I wonder why that argument doesn't come up more when we consider this.
So I'll take a shot at why. This is not to say I agree with this, but this is, I think, what the argument is. So Cruzon is, I think, the most relevant Supreme Court case, right? Cruzon is about a right to resist, right? If you are terminally ill, right, a right to resist potentially life-saving medical intervention. And Cruzon was not, Cruzon is often portrayed as a medical autonomy case. I think those who would read it more narrowly would say it's a case about how even at common law, forced medication was a battery, right? And so forced medical interventions were understood to be protected against, right? Versus the flip side of that, right? Versus your own decisions about medical autonomy that are not just resisting forced intervention. So I think that's the argument for why it doesn't go that way. I'm not sympathetic to it, but I think that's what's out there.
So I think there's a couple things. One, when we're talking about substantive due process rights, you can define them in any sort of level of generality. So you could say the abortion right is about family formation. Well, that seems rooted in our history and tradition. You could say it was about bodily autonomy. Well, that does too. So the more specifically you define it, the modern sort of healthcare rights, right? IVF, right? That didn't exist for any period of time.
FDA approved experimental medication.
Right. The harder it is to find the deep roots in history and tradition. I think I should have probably mentioned, I think bodily integrity is actually one of the rights, it's not listed in the Constitution, that is very much at risk. And again, I describe this greater and lesser. We will see forced C-sections. We know that because we've seen them. But they were illegal. They were unconstitutional. We will see forced interventions. We will see forced bed rest. And there's this really weird passage where Justice Alito says the other rights he describes are different. And I don't think this has gotten much attention, but he says something like, in some circumstances, rights against medical intervention. And that gave me chills because there are no rights that are absolute. every right he was describing, the right to marry is only available in certain circumstances.
Right. You can't get married if you're already married.
Yes, or to your cousin in most states, those sort of things. So that was sort of chilling to me, and I think a signal that we will see intrusions into the right to bodily integrity. I think initially with pregnancy and people of reproductive age, and then beyond that.
And I think this might be a helpful place to close. Like, I think, it is a common rhetorical trope among those who would defend the majority opinion in Dobbs that its critics don't offer an independent, freestanding defense of the constitutional right to abortion, and that's just hogwash. I mean, right? There are any number of freestanding, coherent, principled defenses of the constitutional right to abortion, and the problem, as Professor Sepper says, is the trap, right, that the Supreme Court's modern jurisprudence creates, especially the so-called Glucksberg test, right, and its requirement that these rights be articulated with a sufficient level of precision. Well, the more clearly and specifically articulate the right, the less you're going to be able to find any historical tradition for it, even if we accept that historical tradition is the right baseline. And so, I think there's, we could do a whole nother hour on the affirmative case for a constitutional right to abortion. But I think I didn't want to sort of leave it alone that there's just that case doesn't exist. Not only does it exist, but it's actually a pretty strong one. And it's, I think, in some ways more coherent than the notion that, well, it's not in the Constitution, therefore it's not a right. That's a view. It's not a view that most of the people who say it actually hold. And I think it's going to cause only that much more mischief, right, as we see the next generation of cases. So I guess we'll have to do this again.
In the next generation?
Yeah, in a month. So thank you, guys.
Thank you.